A very warm welcome to another special edition of Lunch and Learn, where we will be discussing divorces during our whole process of Divorce Awareness Week. Welcome to all the registrants, the people that have registered, and all our online viewers on our different social media platforms, as well as our website. And today we will be discussing the issue of, should you file for divorce first? What are the benefits? What are the disadvantages of, as well as disadvantages of filing for a divorce first, the pros and cons thereof? And then we'll be discussing interim maintenance or orders, interim or not necessarily maintenance, but also interim orders, because the process of divorce might be a lengthy process and there needs to be some interim relief that we will be discussing as well. And one of my very good colleagues, Mervyn Vermeulen, will be addressing those issues as well. Just to get some logistics out of the way, the Divorce Awareness Week has been proudly presented and given out and broadcasted all over social media by our legal firm, Oppermans Incorporated. And you're most welcome to drop me an email should you need any assistance with your divorce or have any queries or comments. Even you can drop me a personal email on eugene@oppermansinc.co.za or on our general Lunch and Learn inbox on info@lunchandlearn.org.za. What we will be discussing today, just the course overview, what we will be discussing is, should you file for a divorce first? The pros and cons. We will go into some detail of the benefits thereof and the disadvantages thereof as well. And then we will be spending quite some time on the whole question of divorces that take very long, and what type of interim orders can be made by the court in order to assist you during this whole lengthy process of divorce. And then the last question that we will be addressing is that, and this usually pertains to the customary marriages, if you want to get a divorce, but your divorce has not been formally registered. Just to get some of the further logistics out of the way, if you have registered on our website, www.lunchandlearn.org.za, you would have received a link bringing you to the website. We would also give you the opportunity, if you check the resource and templates folder, where you can download a copy of the slides that we will be discussing today, as well as a webinar handout containing all the information that has been discussed during this webinar today. If we make reference to certain cases, we will also put that there. If there's any documents that is additional to what we have been discussing, then that would be found there as well. But without further ado, let's jump right into the whole question of, should you file for divorce first, the pros and the cons. Number one is now, and we will be dealing with the benefits of filing for the divorce first. So you would be the plaintiff in this matter. You would approach an attorney in order to draft the necessary documents, and that documents will be served upon the respondent or the defendant, your soon-to-be ex. So the benefits thereof, one of the benefits would be, it's the benefit of control, that you would be the driver as the plaintiff of this whole process. You would have full control over this whole process. And it also, I found that in many instances, if you've come to a stage where you realize, you get the realization that the marriage is over, and it would inevitably land up in a divorce or end up in divorce, that you would have a psychological benefit thereof and a sense of accomplishment and achievement during this process. And that is only if you start the process yourself. Remember that we work with a no-fault system in South Africa, which means that the only way, or the only reason that you need to present to court, is that the marriage has been irretrievably broken down. So it's not necessary for you to gather all the evidence of infidelity and so forth, because we work with a no-fault system in divorce. One of the other benefits with regards to filing for divorce first is that you would have control over the timing of the divorce. You would decide when you feel ready to do that. Remember that during this whole process of divorce, if it is uncontested or even a contested divorce, that there are certain time periods that documents need to be exchanged and so forth. So you, as the plaintiff, would have a sense of control over the whole process of the timing of the divorce, specifically when it comes to initiating divorce. When the timing is right for you. So that is also one of the benefits. You would also have the benefit of the element of surprise, that your soon-to-be ex-spouse might not be aware that you are filing for divorce. So the element of surprise might come to your advantage in this whole process. Another thing, also one of the benefits of filing for divorce first, is that you can check if your partner is hiding assets, and that's specifically pertaining to marriages in community of property, where you would be entitled to half of the proceeds of the assets when it comes to divorce. So beginning this whole process before filing for divorce ensures that you've got an accurate idea of what could be considered to be the marital property that you are entitled to, without the opportunity for your spouse to actually then move or to hide any of the assets or the information that is needed regarding those assets. It also allows you to consult and retain an attorney of your choice. It happens quite often that I have a client that I have represented previously, but then their spouse comes to me for a divorce. And as an attorney, as a legal practitioner, you cannot act for both parties unless it is an uncontested divorce and the parties agree to that. So yes, definitely one of the benefits would be that you could retain an attorney of your choice. So it's basically, you know what, phone us before your spouse does type of a scenario. Another benefit would also be that should the matter proceed to trial and formal litigation, that the spouse who have filed first, that issued the summons, would not only get the chance to present the evidence and the witnesses to the judge first, but you will also be able to rebut your spouse's responses to witnesses, evidence, and closing arguments. So this might be an advantage because you would have the opportunity to attack the credibility of the story of the spouse in their attempts of putting their information and their evidence to the judge. One of the other benefits might also be that there is a sense of relief, because there's usually divorce never happens overnight. It usually, there are circumstances and there are situations, and it leads up to the whole process of divorce. And you might feel a sense of relief now that you've realized that divorce is inevitable, that the marriage is over, and that the emotional toll being put upon you is actually now alleviated because you started the whole process. Another one of the benefits would also be the choice of jurisdiction. That specifically happens where the parties might be in different provinces, where you can institute proceedings in the court that has jurisdiction over yourself, and you need not file in the other province, which would mean that you have to go to the other province in order to have the matter trialed if the matter goes to trial. So the choice of jurisdiction would also be one of the biggest benefits of filing for divorce first. Some of the disadvantages of filing for divorce first would obviously be you might alert your spouse to your demands. So during the divorce process, the issuing of the summons and the particulars of claim, you need to set out exactly what you want so that your spouse would have first-hand knowledge of your demands. And that might be considered to be a disadvantage at one stage. Your spouse will then know the demands, and they will be able to prepare their counter demands or their counter claims accordingly. Is that a big problem in terms of South African law? I do not think so, because that would also just prolong this whole process. So the sooner you start with the process, the sooner the counterclaims can be there, the sooner the parties can enter into meaningful mediation in order to reach a settlement if it is at all possible. Fees, yes, there is also, if you institute divorce first, then obviously you need to carry the cost of the legal practitioner or your legal representative. You have to give them a deposit for them to start the whole proceedings and to go to court. Now, that is usually, if you agree upon a set fee, or you work on a billable hour system, that is things that we've discussed in previous webinars. That is something, the aspect of cost that you need to deal with specifically with your legal representative. But yes, most definitely, if you start the proceedings, then there needs to be funds paid into the attorney's trust account for them to start with the whole process and issue summons. One of the other disadvantages of issuing the summons first is that there might be some feelings of resentment and mistrust, not only between the parties, but also between the family members. The whole misconceived idea of, you know what, I am divorcing him type of scenario, or I am divorcing her, that you might be branded as the black sheep of the family. So that might be one of the disadvantages of filing for divorce first. Commonly asked questions is that, can both parties or both spouses file for divorce first? The answer is no. The divorce process is considered to have started once one of the parties have issued the summons through court. So if there is a court date, and not a court date, a court case number on the summons, then that is considered to be the time that divorce has started. So it is not up to the parties. It happens quite often in practice where there might be a delay in the service, the personal service of the documents on the other party, and that the ex-spouse or the soon-to-be ex-spouse, the defendant in the matter, also issues summons. And then they usually look at the date that the summons was issued. Only one party can institute a divorce proceedings in terms of South African law. Common misperception: if I file for divorce first, do I get the custody of the children? The answer is no. That is not a point blank or blanket given that if you file for divorce first, that you would have custody of the children. It is all in terms of our Constitution, Section 28. It's all for the benefit of the children. So it's definitely not a given that if you file for divorce first, that you would get custody of the children, because the interest of the children needs to be met. Obviously, if there are children involved, then the Office of the Family Advocate would also get involved to see what is the benefits for the children, and where they should stay, and who should have primary care, and so forth. As I've mentioned now, the whole divorce process might take a very long time. I've had cases in the High Court that dragged on for probably 5-6 years, and that might put a financial burden on one or even both of the parties, because it might be acrimonious. The parties do not agree on certain aspects, and then it's attorneys fighting with each other, and there's correspondence, and there's paperwork, and it's usually piles and piles of discovery of assets and so forth. And that might take a very long process. But in this whole process, you, as either the plaintiff or the defendant, might end up with a situation where certain issues needs to be discussed, and that needs immediate attention. And some of those issues might be interim care and contact of the children. Where will the children stay? Situations do change, and that needs to be adapted. There needs to be a process where you can approach the court to say, but you know what, we need to address this specific item of contention or problem that we need to discuss pending the finalization of the divorce. Things like maintenance, child maintenance, for example, even spousal maintenance needs to be addressed. The enforcing of certain payments, you know what, your spouse moved out of the communal home, the bond needs to be paid. Who pays for that? That might land you into some financial difficulties if that specific problem is not addressed. Accommodation and relocation costs. If you were in an abusive relationship and you moved out and you need to find alternative accommodation for yourself, there might be children involved as well. The cost aspect thereof. Obviously, the costs of litigation and the legal fees, that could also be a problem, because you might run into a problem where you simply do not have funds to litigate. That needs to be addressed as well. It might be orders for delivery of a vehicle because your spouse took the vehicle or the car, the furniture, and so forth. So there needs to be a mechanism where the court could intervene to say, but you know what, we can give you interim relief pending the finalization of the divorce. Now, in terms of South African legislation, there are two ways that could be done, and that is done through a Rule 43. And that is governed by the Uniform Rules of Court, which is done in the High Court. So if you instituted your proceedings in the High Court, then you would make use of Rule 43 to get these interim orders. Same scenario if you used the Regional Magistrate Court in order to issue summons, then Rule 48. Rule 58, would be applicable to those circumstances, that you can bring an application to court to get the interim relief. So what is a Rule 43 interim order? Now, I'm one of my colleagues, Mervyn Vermeulen, did a talk on specifically what is Rule 43 and how does it work and where you can apply for that. And I'm handing over to him just to explain to us in short terms, what is the Rule 43 interim order? But bear in mind that if you institute proceedings in the regional court, the magistrate court, then Rule 58 would be the comparative rule dealing specifically with that.
What is Rule 43? And this is the definition that I've tried to postulate in one sentence. Rule 43 is an expeditious and robust High Court application which is designed to, by means of interim court order, give rise to a tenable and fair temporary status quo in respect of maintenance, legal costs, and care and contact of minor children, pending finalization of the litigation in divorce matters. Rule 43 is designed to be expeditious and robust. Expeditious simply in terms of they are meant to be dealt with quickly. They are not intended to bloat. Rule 43 matters are dealt with in a robust fashion. They really do require the judges hearing them to make very decisive orders to set in place this status quo in an interim fashion. What is the end result of a Rule 43? Unless it gets dismissed, you get an interim court order. It has all the full force of a court order, but it is interim in nature. The minute the divorce is granted, it falls away completely and is replaced by whatever the trial court decides in terms of the final outcome of the divorce proceedings. It is meant to give rise to a tenable and fair temporary status quo. The Rule 43 court is not going to reinvent the wheel. The Rule 43 court, in the truest sense of the word, is designed to put parties in a holding pattern where they can get to court properly and without one party having an unfair advantage over the other. Rule 43s deal with maintenance, contributions to legal costs, and care and contact in respect of minor children. And as I mentioned previously, they operate pending finalization of the litigation in divorce matters.
Thank you for that, Mervyn. So just to recap what he said, was that when can the Rule 43 or the Rule 58 be used? And it could be used in one of the following scenarios: where there's interim care or contact with a child needed. The court needs to decide on that. Maintenance for the wife and or the children, enforcing certain payments such as bond repayments on the matrimonial home, vehicles, school fees, medical aid premiums, and so forth, as well as even deposits on new accommodation because you moved out of the house. That could also be dealt with a Rule 43 or a Rule 58 application, and also interim contribution towards the legal costs of the one of the parties. And the Rule 43 and 58 could also be used as an order for delivery of certain items, such as a car or furniture and so forth. Just to amplify what Mervyn said, it is an interim solution. It is not the final order. It's usually used because it was brought in because in the normal sense, if it is an extremely high conflict or acrimonial divorce, it could take years to finalize, and the parties need to safeguard their needs during the whole process. There's also the equality provisions in the Constitution where parties need to litigate on the same basis. And that is usually where the legal costs aspect or the contribution towards legal costs comes in, where the lesser party would be on equal footing with the other party when it comes to employing an attorney to bring the matter to court. So when can this application be brought? Obviously, it could be done even before the issue of the summons. It could also happen simultaneously when you issue the divorce summons, or even during this whole process of divorce. Then a Rule 43 or a Rule 58 application could be brought. The process thereof, just in short, and I'm sure Mervyn will allude to that, it is basically an application that is brought to court on an urgent basis. Like Mervyn said, it needs to be dealt with in a robust manner, and it usually starts off with one of the parties wanting the interim relief, usually the applicant or the complainant, that will file a notice and an affidavit setting out the facts relating to the divorce and why that specific spouse is of the opinion that she's entitled to the relief from the other spouse. There needs to be certain documentation that needs to be submitted. It's usually done by way of affidavit. You need to prepare, or your attorney or your legal representative needs to prepare a notice in terms of the Rule 43 or 58, and then requesting the respondent to file an opposing affidavit within a period of 10 days. Together with your application, there also needs to be an affidavit giving rise and explaining to the court what type of relief you are seeking, as well as all the annexures that proves your income, your expenses, your assets, and so forth. Just bear in mind that the other party can then oppose this application, and then they also need to file certain documentation giving rise to their counterclaim if they do not agree with the application. So without further ado, I'm handing over to Mervyn to explain exactly what can be done with regards and what can be claimed in terms of a Rule 43 and a Rule 58 application.
This rule shall apply whenever a spouse This rule shall apply whenever a spouse seeks relief from the court in respect of one or more of the following matters. And then it lists 4 aspects. 1, maintenance pendente lite. 2, a contribution towards the costs of a matrimonial action pending or about to be instituted. Interim care of any child, and interim contact with any child. Those really are the 4 pillars on which Rule 43 applications are adjudicated. Ladies and gentlemen, a very, very notable absence, if we look at the wording of Rule 43 sub 1, is guardianship. As I mentioned, the 4 walls of Rule 43 are Maintenance, contribution towards the costs of a matrimonial action pending or about to be instituted. Interim care of any child and interim contact with any child. First off, we start with maintenance pendente lite. Pendente lite, ladies and gentlemen, simply means pending the litigation. So this is a maintenance order that will be in place until such a time as the litigation is finalized. Maintenance can be divided up into 3 categories. First off, we deal with maintenance for minor children. Thereafter, maintenance for major dependent children. And then finally, our very favorite spousal maintenance. Right. What form can a maintenance claim under Rule 43 take? Number 1 is periodic payments of money to the applicant. Number 2 is periodic payments of money to service providers, i.e. school fees. Number 3, assets can be made available for use by the applicant, and that is Van der Spy versus Van der Spy 1981. It is a reported judgment that you can refer. Then let's look at the second thing that one can deal with in Rule 43, and this is a contribution towards the costs of a matrimonial action pending or about to be instituted. And some of the most bitterly fought Rule 43s that I've seen have been fought over this contribution to costs. The key principles in contributions to costs, I think, are fourfold. Number 1, to get a contribution to costs, the applicant must show a prima facie case if they are the plaintiff, or they must show that they have a sound defense if they are the defendant. They don't have to prove that defense, they must just show prima facie. In other words, they must show enough facts which, if proven, would give them a valid case and or a defense. Then, incredibly important, folks, when you prepare your bill of costs for a contribution, or when you attack a bill of costs against a contribution, this has recently, I'll share anecdotally with you, saved my client's bacon. The contribution is only for the costs of the action. Interim applications are excluded. It used to be a very, very well established principle in our law that you are only entitled to future costs. However, we have had the apple cart thrown over with extreme malice by the Western Cape High Court. In 2 cases specifically, AF versus MF 2019 6 SA 422, which seems to suggest and flirts with the idea of allowing claims for past legal expenses. And then we have an unreported case of AG versus LG, which is referenced in Erasmus for those who would like to have a look at it, which really kind of goes the whole hog and says that you can claim past expenses, past legal costs under a claim for contribution to costs. Then let's go on to an interim care order in respect of any child. Care in relation to a child includes, where appropriate, within available means, providing the child with a suitable place to live, living conditions that are conducive to the child's health, well-being and development, and the necessary financial support. You remember I mentioned to you earlier regarding the maintenance, which really finds itself rooted in care of a minor child, and there is the evidence to that effect. Safeguarding and promoting the well-being of the child, protecting the child from maltreatment, abuse, neglect, degradation, discrimination, exploitation, and any other physical, emotional, or moral harm or hazards, respecting, protecting, promoting, and securing the fulfillment of and guarding against any infringement of the child's rights set out in the Bill of Rights and the principles set out in Chapter 2 of the Children's Act. guiding, directing, and securing the child's education and upbringing, including religious and cultural education and upbringing, in a manner appropriate to the child's age, maturity, and stage of development. Guiding, advising, and assisting the child in decisions to be taken by the child in a manner appropriate to the child's age, maturity, and stage of development. Guiding the behavior of the child in a humane manner, maintaining a sound relationship with the child, accommodating any special needs that the child may have, and generally ensuring that the best interests of the child is the paramount concern in all matters affecting the child. Once again, ladies and gentlemen, the Act talks about interim contact with any child, not maintaining a personal relationship with a child. And if the child lives with someone else, communication on a regular basis with the child in person, including visits and being visited. And 2, communication on a regular basis with the child in any other manner, including through the post. I love that they still have through the post there. And then secondly, by telephone or any other form of electronic communication. WhatsApp and Skype and Teams and Zoom and all of these wonderful things that we have these days. So contact, ladies and gentlemen, is not simply a midweek visit and a every second weekend visit. It is much more than that. Yes, it is under subsection B, Roman numeral 1, in-person visits, but it's more than that. And primarily, it's not just visits. Contact is not visitation. It's not access, as they used to call it. It's maintaining a personal relationship with the child. And that then goes into the B section. A is the what is contact. Contact is maintaining a personal relationship with a child, and I would go so far as to say B is the how. And you do that by communication on a regular basis, either in person or by alternative means.
Thank you for that, Mervyn. A couple of things that I want to bring to your attention as well, because as Mervyn said, it is a robust application. It is an application that is brought interim to address certain issues. It might be maintenance, it might be legal costs, it might be care and contact and so forth. So that is an urgent application that is usually heard on an urgent basis by the courts. Now, I've found that because it's an expeditious application that is brought, that and I've had in the high court cases where people file 600 pages of affidavits stating their case and wanting to use this process of Rule 43 or 58 as trial proceedings and to litigate the whole process of divorce. And that is not the aim of a Rule 43 or a Rule 58. It is in order to give you an expeditious way of addressing a certain issue pending the finalization of the divorce. So if you rock up to court with 600 pages of affidavits and documents trying to prove your case, then the judge might look onto that and say, but you know what, if you had time to prepare 600 pages for a Rule 43 application, then it is not an urgent application anymore because you want to try and litigate that as if it was the main action of divorce. Another thing that I would like to discuss is that what can you do if you are dissatisfied with the ruling or the judgment of the Rule 43 or the Rule 58 order? Now, to start off with, you cannot appeal a Rule 43 order. It is not appealable because it is an interim order. It's not appealable, and the courts are not prone to have you appeal that matter. Having said that, if there is certain circumstances that have changed during this whole process, then most definitely there is a way that you could vary the Rule 43 order, and we see that happening quite often because circumstances do change. The visitation of the children, parties moving away into province, and so forth. Then that would necessitate the changing or the variation of the Rule 43 order, but you will have to need to establish that there was a change in material circumstances before you could actually bring such an application to court. And it is also available, that remedy is also available, the variation thereof is available to both litigants if they believe that there is a change in the material circumstances that they could prove to the court. That is just basically the roundup of the Rule 43 that could be brought pending the finalization of the divorce. The final issue that we need to discuss is specifically pertaining to customary marriages, and that is dealt with the Recognition of Custom Marriages Act. And that usually happens when the parties are married through customary law, and there was some kind of function or ceremony indicating the establishment of what they perceive to be a marriage between customary tribals and paying the lobola and so forth in order to establish if there was a marriage. Now, in terms of the legislation, the Recognition of Customary Marriage Act, those marriages need to be registered at the Department of Home Affairs in terms of Section 4.1 of the Act. And then they usually have a period of 3 months to register that. And I found that in so many instances, the people forget about that. You know what, they're on their honeymoon phase and they clearly forget to register that at the Home Affairs. Now, and then they subsequently want to get divorced, but their marriage was never registered at Home Affairs. Section 4.9 of the Recognition of Customary Marriage Act actually says that failure of the non-registration does not affect the validity of that marriage. So you could actually afterwards approach Home Affairs to give them the necessary documentation. You know what, if you paid lobola and so forth, then you could actually give that type of evidence to Home Affairs establishing that you were indeed married in terms of customary law. If you are not in an area where there is a Home Affairs, then you can approach, in certain instances, you can approach the traditional leaders to register the customary marriage. Now, that was basically just a rundown as a summary, the Rule 43 applications, which is and the Rule 58 applications, which are interim orders that you could get pending the finalization of the divorce, and then as well as just making reference, because that was also a question that came through on our email with regards to customary marriages. Thank you so much for joining us today. Just as a side note, you are most welcome to visit our website, www.oppermansinc.co.za, or you could scan the QR code, which is on your screen, and then you could have the following ebooks that we have written that is available for distribution that you could read beforehand or afterwards as well. And it pertains to divorces. I've written 2 books specifically on divorces. The one with, everything that you need to know before you file for divorce. We also wrote a separate ebook dealing with same-sex marriages in terms of the Civil Union Act. One ebook that you could also download is dealing with narcissism when it comes to divorce matters. And then, which we'll probably address tomorrow, is the question regarding maintenance, spousal maintenance and child maintenance. You can download that book as well, giving you some information. It's all written by attorneys in clear and simple terms without the legal jargon that you might find that the attorneys use. And then the last ebook, the latest in our range, is Divorcing with Dignity, which focuses more on the mediation part of dealing with divorce and going through the whole divorce process with dignity. Thank you so much for joining us today. This has been great fun hosting this for you today, and it's been proudly presented by or sponsored by our firm, If you would like to make contact with us, if you have any queries, please drop us a line on eugene@oppermansinc.co.za, or you could use the Lunch and Learn inbox, info@lunchandlearn.org.za. Thank you so much for joining us, and thank you to Erin as well for compiling the course handout. Thank you so much. Please do read the disclaimer at the end, and we'll be seeing you soon for another episode of Lunch and Learn, the special edition focusing specifically on divorces. Have a good afternoon further.